Hi guys, Shannon Marino. So I've wanted to talk to you guys a little bit about probate. What is probate? What's the big deal with it? Because a lot of people hear that you want to avoid probate. That's the entire point of estate planning. So probate is a court. That's all it is. It's simply a court process. Just like we have criminal courts and traffic courts and family courts, we also have probate courts. So, what the probate court does is the probate will substitute your signature for a court order if you are not capable of signing something. Okay, so what would be the reasons that you're not able or capable of signing something? So, if you are incapacitated, maybe you are in a coma, or perhaps you have advanced dementia and you are unable to make decisions for yourself. Um, that means that you are unable legally to sign your name to documents, to commit yourself to documents, and to make legal decisions. And therefore, somebody must do that for you. So the court will step in those types of cases to substitute your signature for an order. Okay, so the court will appoint somebody to act on your behalf, and that person can enter legal agreements on your behalf when you are unable to. The second type of probate, or most common type of probate, would be if you pass away. So if you pass away and you own stuff in your name, you are not here to sign over title or to give out your stuff to other individuals. So the court will substitute for your signature. The judge will come in and the judge will take a look at who the rightful heirs are according to state statute. And then the judge will enter an order substituting your signature on those different assets or those personal items that you may have, and have the title renamed in that heir's name. Okay, so the court order will substitute for your signature to transfer that asset. And then the last thing that the court, well, third most common thing that a court really will look over is minor children. So again, in those two scenarios, so if you pass away and you have not named somebody to take care of your children, or perhaps you are incapacitated and are not able to take care of your children, maybe you pass away and you do appoint somebody to take care of your children, but you have named your children as a beneficiary on an insurance policy, meaning your children are supposed to get a lot of money. Children cannot legally manage or take custody of large sums of money. So the court will appoint somebody to watch over their financial affairs. So I see that all the time in my personal injury practice with settlements. Really, the court's job is to oversee the funds until that child turns either 18 or 21. It depends on your state. And so the court will monitor the funds on a yearly basis and will appoint somebody from a day-to-day basis to watch over the funds for your minor child. If you've not named somebody, the court will also name somebody to watch over your children and care for your children from a day-to-day perspective or standpoint. So those are the most common ways that people find themselves into the probate court system. And it's costly. It's also very time consuming, months and possibly years if there's a contested action. So it's definitely in your best interest. It's definitely in your loved one's best interest to try to avoid the probate courts altogether so that you're not having to deal with a court process, potential for family conflict if somebody perhaps doesn't agree with you. And it makes things in a transition when your family is dealing with death or incapacity much more seamless and much easier to deal with, considering they're also probably dealing with a large emotional issue or problem that really needs their focus in other ways. So that's what probate is all about. Definitely avoid it. You can avoid it by doing trusts and utilizing other legal mechanisms. Feel free to contact me if you have any further questions. Bye, guys.